not in deference to political outcomes, that the legitimacy of this court's intervention ultimately rests. Accordingly, we find that the impeachment proceedings challenged in these petitions are justiciable, and that this court possesses jurisdiction under Articles 23, 22, and 165 of the Constitution to determine whether the National Assembly and the Senate acted within constitutional bounds, complied with constitutional procedures, respected constitutional rights, and remained faithful to the constitutional safeguards governing the impeachment of a deputy president. Second sub-issue, predetermination and bias. The petitioners contended that the impeachment proceedings against His Excellency Rigathi Gachagua was tainted by actual bias, apparent bias, conflict of interest, and predetermination on the part of the speakers of the National Assembly and the Senate, members of Parliament, senators, and other constitutional actors involved in the impeachment process. It was their case that various public statements, political conduct, and procedural decisions demonstrated that the outcome of the impeachment had effectively been determined before the proceedings commenced, and that the constitutional actors involved had failed to approach the process with the impartiality and openness required under Articles 27, 47, and 50 of the Constitution. The constitutional foundation of the petitioner's claim lies principally in Article 27, 47, and 50 of the Constitution. Article 27 guarantees equality before the law and the equal protection and equal benefit of the law. Article 47 guarantees every person the right to administrative action that is lawful, reasonable, and procedurally fair. Article 50, sub-article 1 guarantees every person the right to have any dispute that can be resolved by the application of law determined in a fair and public hearing before a court, or where appropriate and independent and impartial tribunal or body. The constitutional requirement of impartiality is not confined to court of law. Whenever a constitutional body exercises adjudicative, disciplinary, investigative, or quasi-judicial authority affecting rights, interests, status, or public office, the process must comply with constitutional standards of fairness, impartiality, and procedural propriety. This principle was affirmed by the Court of Appeal in Sholei versus Judicial Service Commission and 3 others in 2013, and the Judicial Service Commission versus Mbalu Mutava and another Civil Appeal number 52 of 2014. Where the court emphasized that constitutional and administrative decision-making processes are subject to the requirements of procedural fairness and natural justice. In Mbalu Mutava, which I have mentioned above, the Court of Appeal observed that Article 47 transformed the common law principles of natural justice into constitutional imperatives, such that whenever public power is exercised in a manner affecting legal rights, status, or legitimate expectations, constitutional standards of fairness become directly applicable. In Sholei case, the Court of Appeal reaffirmed that public bodies exercising disciplinary or quasi-judicial authority must act fairly and impartially, and that public confidence in constitutional institutions depends not only on actual fairness, but equally upon its appearance. The rule against bias is one of the oldest and most fundamental principles of natural justice, embodied in the maxim Nemo Judex in Causa Sua, that no person shall be a judge in their own case. Historically directed at preventing decision makers from participating in matters in which they held a personal, financial, or proprietary interest, the doctrine has over time expanded to encompass circumstances giving rise to a reasonable apprehension that a decision maker may not approach a matter with the requisite impartiality, even in the absence of any direct personal interest. The modern test for apparent bias was authoritative stated by the Supreme Court in Rai and 3 others versus Rai and 4 others, 2013, KLR, where the court adopted the objective test and held that the inquiry must be conducted from the perspective of a fair-minded and informed observer. The court emphasized that allegations of bias cannot be founded upon speculation, conjecture, suspicion, or dissatisfaction with the outcome of proceedings. There must exist objective circumstances capable of giving rise to a reasonable apprehension that the decision maker may not bring an impartial mind to bear on the subject. The Supreme Court reaffirmed and elaborated upon these principles in Kaplana, Rawal, and two others versus Judicial Service Commission in 2016. Observing that the question is not whether a party genuinely believes that a tribunal is biased, but whether a reasonable and informed observer, having considered all relevant facts, would conclude that there exists a real possibility of bias. The court further recognized that constitutional institutions must be protected from unsubstantiated allegations capable of paralyzing their functioning, and accordingly insisted upon an objective evidentiary foundation before in principle first established in R versus Sussex Justices ex parte McCarthy 1924 1 KB 256 that justice must not only be done but must manifestly and undoubtedly be seen to be done, and underscored that public confidence in constitutional institutions depends significantly upon the appearance of impartiality and not merely its substance. From these authorities, several important principles emerge. First, the test for apparent bias is objective, not subjective. Second, the inquiry must be conducted from the standpoint of a fair-minded and informed observer. Third, mere suspicion, political disagreement, dissatisfaction with a decision or an adverse outcome does not, without more, establish bias. Fourth, and critically, there must exist objective circumstances capable of giving rise to a reasonable apprehension that the decision maker did not or could not approach the matter impartially. Jurisprudence further establishes that bias and predetermination, though related in concept, are legally distinct. Bias concerns the existence of actual or apparent partiality or on the part of the decision maker. Predetermination concerns a state of mind in which the decision maker has effectively closed their mind to the evidence and argument and reached a final conclusion before the process has run its course. The distinction was illuminated by the English Court of Appeal in Lays versus Redder and Cleveland Borough Council in 2008, where the court drew a clear line between predisposition and predetermination. Decision makers may legitimately hold predispositions, inclinations, or preliminary views on matters before them. That is the inevitable consequence of experience and engagement in public affairs. What the law prohibits is predetermination, which is a state of mind so closed to persuasion that no amount of evidence or argument is capable of altering the ultimate outcome. In light of the authorities that we have cited, we hold the view that the mere fact that members of parliament or senators publicly supported or opposed the impeachment of His Excellency Gachagua cannot, standing alone, establish constitutional bias. To hold otherwise would render impeachment proceedings practically unworkable and would be inconsistent with inherently political character that the Constitution itself recognizes in such proceedings. Legislators are not expected to approach impeachment as blank slates devoid of political opinion or prior knowledge. What the Constitution requires is that they remain genuinely open to considering the evidence, listening to argument, and discharging their constitutional responsibilities in good faith and within constitutional limits. We are accordingly not persuaded by the proposition that bias may automatically
hold required under Articles 10 and 118 of the Constitution. Second, whether the Senate, upon receipt of the impeachment motion, was itself obligated to carry out a public participation exercise before voting on the impeachment. And third, whether the public participation was required at the point of nomination and appointment of His Excellency Kindiki as Deputy President. The petitioners collectively contended that public participation in the impeachment process was constitutionally deficient, inadequate, and in certain stages wholly absent, rendering the entire process null and void. Their challenge was mounted at the three levels, and the petitioner advanced, they attacked the National Assembly's public participation exercise as being deficient, both in substance and procedure. They argued that the public was given less than 48 hours to digest complex charges, that the template used reduced their participation to binary support or not support choice, that His Excellency Gachagua'S own response was withheld, depriving citizens of balanced information, that many venues were inaccessible, changed without notice, or restricted to party members. They also pointed to defiance of conservatory orders requiring constituency-level hearings, vagueness of the same-day notice of the 5th October 2024, anomalies in the participation report, such as a report support rate exceeding 100%, and tabling of that report moments before the debate. They also concluded that the scale of participation of about 200,000 citizens out of a population of 52 million was negligible and incapable of meeting the constitutional standards. With respect to the Senate, they contended that Senate conducted no public participation at all, no notices were issued, no hearings convened, no submissions received. They emphasized Senate's role was determinative and quasi-judicial, and therefore attracted an independent obligation to facilitate public participation. They argued that this obligation could not be discharged vicariously through the National Assembly, and that by proceeding without its own engagement, the Senate compounded the defects of the Assembly's process and arrogated sovereign power that the Constitution requires to be exercised by the people. Finally, they challenged the approval of H.E. Kindiki as Deputy President and argued that no public participation preceded the vote, yet that approval constitutes what is known as other business under Article 118(1)(b), which requires public involvement. They highlighted the compressed timelines in the Senate impeachment vote on the 17th of October, the nomination of His Excellency Kindiki the same night, and approval by the National Assembly the following morning as evidence that the process was concluded overnight without public input. They distinguished this midterm vacancy scenario from a general election, noting that in elections, the people exercise sovereignty directly through the ballot, whereas in midterm appointments, public participation is the only available mechanism for engaging the people's will. And on that basis, prayed for declaration that the nomination, approval, and appointment of His Excellency Kindiki were unconstitutional. The respondents, quite in summary, maintained that the National Assembly's public participation exercise was adequate, it was reasonable, and fully compliant to the constitutional requirements. They argued that notices were disseminated through the Gazette, through newspapers, through Parliament website and social media, and that multiple channels of participation were available. They defended the 2 to 3 day notice period as reasonable, given the strict timelines under Article 145. They further justified the tick box template as a deliberate design to structure responses and prevent manipulation, noting that citizens could still submit their memoranda or oral views. They argue that participation by over 223,000 citizens was characterized as unprecedented civic engagement, and they dismissed the isolated disruptions as immaterial. They argued that there was no obligation to share His Excellency Gachagua'S report with response with the public, since the public's role was to express views, not to adjudicate. On the Senate stage, the respondents, in summary, contended that the public participation was not required, as the Senate sits as a quasi-judicial capacity during impeachment, and not as a legislature. That Article 118 applied only to legislative business and not impeachment. That impeachment was a single continuous exercise with the public participation required only at the initiation stage. Regarding the nomination and approval of His Excellency Kindiki, they submitted that public participation was not required, that Article 149(1) established a unique self-executing process where the National Assembly voted as an electoral college exercising delegated sovereignty rather than conducting legislative business, that the Constitution's silence on participation in this context was very deliberate, and that elected MPs themselves embody public representation, that the debate was open, televised and recorded, and they concluded that the nomination, approval, and appointment of His Excellency Kindiki were fully compliant with the Constitution. We have considered the cases advanced by both parties and take the following position on this issue. It is common ground among the parties, and this court affirms that public participation is not merely a procedural formality, but a foundational constitutional value, one deeply woven into the democratic fabric of this nation. It is an expression of the sovereign will of the people, who, by virtue of Article 1, Sub-Article 1 of the Constitution, are the ultimate repository of all sovereign power. That sovereignty, though delegated to state organs under Article 1(3), is not thereby surrendered. It is retained by the people and continuously exercised through, amongst other mechanisms, active and meaningful participation in the process of governance. Public participation is therefore not a gift of the state to the citizen, but a constitutional right that the state is obligated to facilitate, to protect, and to give full effect to. Under Article 10(2)(a) of the Constitution,